Chairman, and thank you again. I guess I'd like to start by picking up on your discussion with Senator Hatch about the Citizens United decision. Senator Hatch talked about a book with a single mention of a candidate and pamphlets designed by small S-chapter corporations. But of course, as you indicated already, what Congress addressed in the McCain-Feingold bill was TV and radio election advertising right before the election, paid for out of the treasury funds of unions and corporations, both profit and nonprofit. So it was the Supreme Court that instead reached out and asked for re-argument and called into question a 100-year-old statute that prohibited corporations more generally from spending money on elections. I just want to clarify this. So let me ask you, wasn't it highly unusual, if not unprecedented, for the court to do this?
Senator Feingold, the United States government in the case did urge the court not to decide the case on the grounds that it did. And you know, it's obviously unusual whenever the court reverses a precedent in this way. The court thought it had grounds to do so, but it is an unusual action, yes.
And wasn't it unusual how they got to the point where they could make that decision based on the facts?
Senator Feingold,
it was unusual, wasn't it?
Senator Feingold, you know, certainly the case as it came to the court did not precisely address the question that the court ended up deciding.
Thank you. And the reason that many people, including the President and many members of the committee, were so outraged by the decision was not simply because the court reversed its 2003 decision upholding the issue ad provisions of the McCain-Feingold bill, but it also reached out to decide an issue that was not raised by the case at hand, an overturned settled law dating back more than a century. Did it surprise you that the court's decision caused such an uproar?
Oh, I don't know, Senator Feingold. I'm not you know, an expert in public reaction to things, and I don't think that the court should appropriately consider the public reaction in that sense.
Do you take note of a public reaction to Supreme Court decisions?
Senator Feingold, I read the same newspapers that everybody else does.
But you're not willing to comment on whether this was a greater reaction than another time?
I don't know, Senator.
All right.
Feingold.
Let me go to national security issues that you already discussed a bit with Senator Feinstein. I think it's safe to say that you agree that the Youngstown concurrence is the appropriate starting point for these types of questions having to do with whether a statute is something that can be overridden. Go back to your understanding of how to apply Justice Jackson's test. Specifically, do you read it to allow for any circumstances where the President could authorize a violation of the criminal laws that Congress has passed?
Where the President could authorize the violation of criminal laws that Congress has passed. Senator Feingold, I couldn't think of any circumstance offhand. I don't want to say categorically that there might never be one if something was very much at the core of presidential power under Article 2, but it would be a highly, highly unusual circumstance.
You used the phrase few and far between, but when pressed about a circumstance where it could occur, the example you gave was not something out of Article 2, which you or out of the Commander-in-Chief power. What you suggested was that, of course, there could be a situation where Congress passes a law that would violate, let's say, the explicit pardon power, which, of course, I concede. But do you know of any examples of where this could occur simply within the context of the Commander-in-Chief powers under Article 2?
Well, it's interesting, Senator Feingold, because I think I read someplace where you stated a hypothetical, which was suppose Congress made somebody else Commander-in-Chief, and the President said, I'm going to ignore that, and I'm going to continue to be Commander-in-Chief. I don't know where I read that you had said that. It struck me as a good example of something where, you know, that's core Commander-in-Chief power.
But you know of no actual example in any court case where the Supreme Court has upheld a presidential assertion of this power in a way that would override a criminal statute. Is that correct?
I do not know of any court case like that. That's correct.
Let me ask you a question I asked Justice Alito about this. What is the proper role here of the judiciary in resolving a dispute over the president's power to disobey an express statutory prohibition?
Well, I think that the court has an important role. I mean, the court generally, I think, has a very important role in policing constitutional boundaries. And that might be policing the boundaries when Congress or some other governmental actor violates somebody's individual rights in a way that's not permitted by the Constitution. Or it might be a case in which one branch impermissibly interferes with another branch or impermissibly infringes on the appropriate authority of another branch. So there are some category of cases, of course, as between the political branches that courts sort of have left to the political branches to work out themselves. And to the extent that the political branches can work their problems out by themselves, I think that that's generally considered, and it's generally right to be considered a good thing. But there are some times when the court really does have to step in and police those boundaries and make sure that the president doesn't usurp the authority of Congress or vice versa.
2007, you gave a speech to Harvard Law School graduates about the rule of law, and you talked about an infamous incident where Attorney General John Ashcroft was asked to authorize an illegal government program while hospitalized for an emergency operation, and he refused. And you told the graduates that they, too, would, quote, face choices between disregarding or upholding the values embedded in the idea of the rule of law, unquote. What prompted you to discuss this theme in this incident in that speech? And do you think that this incident holds lessons for Supreme Court justices as well?
Senator Feingold, was a speech I gave to the graduating class. When I speak to students, and particularly when I speak to them in important moments in their life, like graduation, when they're really thinking about what careers they want to have in the law, you know, I try to tell them some things that will stick with them and be meaningful to them, and some things that I think it's important for them to keep in mind as they start their careers. And the rule of law and adherence to the rule of law, there's no more important thing for any law school graduate to keep in the forefront of his or her mind than that. And that was a speech where I thought that there were some current day incidents, as well as I used some historical incidents to just talk about the rule of law, about how no person, however grand, however powerful, is above the law, to talk about the importance of adhering to the law, no matter the temptations, no matter the pressures that one might be subject to in the course of one's career. And I think that there's nothing more important than that, and that's what I tried to express in that speech. What was it about the Ashcroft incident that fit that category? Well, that was one of the examples that I used as Senator then Attorney General Ashcroft, really taking a very principled stand, and I thought that was notable, and pointed that out, along with a number of others where people have taken very principled stands, notwithstanding some considerable amount of pressure to do otherwise.
Thank you. Let's turn to the Second Amendment. I've long believed that the Second Amendment grants citizens an individual right to own firearms. I was pleased when 2 years ago in the Heller decision the Supreme Court agreed with this view, and as you know, the Second Amendment on its face applies only to the federal government, not to the states, but of course the court just ruled in the McDonald case that the Second Amendment rights apply to the states via the 14th Amendment's guarantee of due process of law. Now, there will undoubtedly be more cases in the future that test the limits of the government's ability to regulate the ownership of firearms. The court in Heller specifically indicated that prohibitions on the possession of guns by felons and the mentally ill, laws forbidding guns in sensitive places such as schools and government buildings, and concealed carry restrictions could pass muster. And the court indicated that the examples it gave of permissible restrictions was not an exclusive list. Now, you worked on gun issues when you were in the Clinton White House, so you're familiar with the kinds of restrictions that Congress has considered, and you're obviously familiar with these Supreme Court cases. Can you give us a sense of how you would approach a challenge to the constitutionality of a law or regulation that restricts gun ownership short of the outright ban and the trigger lock requirement that were overturned in Heller? In other words, how, in your view, should a Supreme Court justice go about deciding whether a law infringes on Second Amendment rights?
Well, Senator Feingold, I think that the court, I have not read all the way through the McDonald decision because it came out yesterday, but I think that it does not suggest anything to the contrary of what I'm going to say. I suspect that going forward, the Supreme Court will need to decide what level of constitutional scrutiny to apply to gun regulations. Some people read Heller to apply strict scrutiny. Other people think that Heller suggests a kind of intermediate scrutiny. I've seen sort of both views of that decision. It's clearly a decision that will come before the court. I think, as you said, the Heller decision clearly does say that nothing in it is meant to suggest the unconstitutionality of certain very long-standing kinds of regulations, and the felon in possession example is the first on that list, but the court also says that the list is not exhaustive. And so I think that there will be some real work for the court to do in this area. I should say that the work that I did in the Clinton White House was all work, of course, before Heller was decided. And so we really didn't, apply this kind of scrutiny, this kind of examination to those decisions. What President Clinton was trying to do back in the 1990s, and what I, as his policy aide, was trying to help him do, was to propose a set of regulations that had very strong support in the law enforcement community, that had actually bipartisan support here in Congress, to keep guns out of the hands of criminals, to keep guns out of the hands of insane people. It was very much anti-crime set of proposals that I worked on back then in the 90s, I think that we did not consider those regulations through the Heller prism just because Heller didn't exist at that time. But I do think that these cases may be coming before the court, and the court will consider sort of regulation by regulation which meets its standard.
Going back to campaign finance issues, again, because of your work in the Clinton White House and your advocacy for the government's position in the Citizens United case, you're very familiar with this area. I obviously care a lot about this issue, and so I'm pleased that obviously your learning curve isn't very steep on this topic. But I'm sure that you've heard that Senator McConnell has attacked you because of your previous work as a policy aide in the area. He thinks you approached election law as a political advocate, and that you were committed to a political agenda, and he says that's, quote, the very opposite of what the American people expect in a judge, unquote. I think it's important to point out that when you were in the White House counsel's office, you had the job of evaluating the constitutionality of various policy proposals. And there you weren't shy about expressing doubts about whether certain ideas could survive a constitutional challenge. For example, in a note to Jack Quinn that was in the documents provided to the committee, you said, I think it's pretty clear that a ban on non-citizen contributions would be unconstitutional. Parentheses, though a ban on foreign contributions would not be, unquote. In another memo to Quinn, you expressed doubt that any constitutionally valid proposal to limit independent expenditures exists. So you said you were, quote, wary of touting this notion to the president, unquote. It seems to me that you were quite aware of the need to think critically and legally as well as politically as you carried out your responsibilities. Can you say a little bit about the process of reviewing draft legislation in the counsel's office and the importance of developing legislation that is consistent with Supreme Court precedent as it exists at the time?
Senator Feingold, I tried my hardest when I was when I worked in the Clinton administration, including as a lawyer, to provide good legal advice to the president. Now, it's a context in which one is dealing with law and policy and politics at the same time. That's the kind of institution it is. But it's very important for political figures and for the policy people to understand what the law requires and what the law permits, and and for lawyers to give good advice on those topics, and that's what I tried to do. I should say that none of what I did in the Clinton White House, whether as a lawyer for the administration or as a policy person for the administration, really has much to do with what I would do as a judge. I know that when Chief Justice Roberts was here and he talked about a position that he had had in the Justice Department, I think, or he separated out those two quite clearly, and I think he was right to do so, that one is simply in a different position, and at the same time as one is trying to provide good and independent legal advice to the president, one is also part of the president's team and doing so in that context, a very, very different kind of context from the context that I would be approaching cases as a judge. But I will say that I think that my experience in the White House during the 1990s is valuable in one sense, which is that it taught me to very much respect the other branches of government. You know, I'm not a person whose experience is only and all about courts. I don't think courts are all there is in this government. I think that the political branches, Congress and the president, are incredibly important actors and should be making most of the decisions in this country. Courts do police these constitutional boundaries, do ensure that Congress and the president don't overstep their role, don't violate people's individual rights. But when it comes to policy, it ought to be courts that do, it ought to be Congress and the president that do the policy making. And the courts ought to respect that and ought to defer to that. And I think that my experience in the executive branch and dealing a lot with Congress has made me very respectful of the president's role and Congress's role in our government.
I think that's an excellent answer. I thank you for it. I'm going to turn to something that requires a little more background now. A question that seems especially pertinent in the wake of the Deepwater Horizon disaster. In 1989, the largest oil spill in American history decimated Prince William Sound when we watched with horror as oil from the Exxon Valdez seeped into one of our most fragile ecosystems and caused tremendous damage. At the time, it was hard to imagine that we'd ever again see an oil spill of this magnitude or this kind of environmental damage. Tragically, we now know better. Now, as was discussed by a number of senators yesterday, after extensive litigation, a jury in Anchorage awarded $5 billion in punitive damages to the plaintiffs in the Exxon Valdez case, which at the time was less than Exxon profits in 1988 and is now less than the total profits Exxon took home in the first quarter of 2010. 19 years after the jury awarded that amount, Alaskan landowners and commercial fishermen had still not received a single penny of that $5 billion award, and we're hoping that the Supreme Court would finally vindicate their claims. But instead of considering the need to punish Exxon and deter this sort of conduct in the future, the court manufactured a new rule and concluded that the award was excessive. In reaching that decision, the court stated that Exxon and other corporations need to have predictability so they can look ahead and know what the stakes are when they choose one action or another. Now, it's not hard to read this decision, especially in light of what's happened in the Gulf, as the Supreme Court giving a free pass to reckless corporations even when our health and environment are at stake. This is also one of many decisions over the last decade where the court has bent over backwards to find a way to protect corporate interests. One of the judiciary's most important roles is to prevent powerful groups and corporations from running roughshod over the rights of individuals. What did you think of the Exxon decision, and do you agree that courts have an important role to play in protecting people who are injured by corporate misconduct?
Well, Senator Feingold, courts have an important role to play in protecting people under the law who are injured by corporate misconduct or by any other. This is an active area of the law, this question of what limits should be placed, if any, on punitive damage awards. And what the Supreme Court did in the Exxon case was really to decide it under its common law maritime powers. This was actually not a due process case, which some prior punitive damages cases have been. Instead, what the court decided, a majority of the court was that there was an appropriate ratio of 1 to 1, I believe it was, for punitive damages as compared with compensatory damages as a matter of federal common law. And the relevance of that fact is that common law typically can be overturned by statute. And so that gives Congress an important role to play in this area. That would, of course, not be the case to the extent that any limits on punitive damages were a matter of the Constitution. But as I understand the Exxon decision was based on common law power rather than a constitutional ruling.
Let me do something completely different. Last year I asked Justice Sotomayor how a Yankees fan could understand the everyday challenges of rural and small-town Americans in Wisconsin who root for the Brewers or Packers. I understand you're a Mets fan, which at least is more the underdog over the history. But
I don't know if it's more the underdog.
Well, traditionally, certainly. So first of all, if you're confirmed, that should make for an interesting dynamic on the court between the two of you. But I want to ask you the same question. You grew up in Manhattan, you were dean of Harvard Law School, and you've lived in big cities most of your life. And there may be a perception on some people's part that you may not completely understand what many Americans are struggling with right now. In fact, at a recent town hall meeting I held in Stevens Point, Wisconsin, one of my constituents asked why nominees to the Supreme Court always seem to be from the East Coast when we have plenty of fine candidates in the Midwest. How will you strive to understand the effects of the Supreme Court's decision in the lives of millions of Americans who don't live on the East Coast or in our biggest cities?
Senator Feingold, does it count that I lived in Chicago for some period of my life?
Getting closer.
Senator Feingold, I hope I've always been a person who's able to see beyond my own background and to listen hard to people. Not only we've talked about listening hard to people of different political persuasions and views, but to try to learn from people who have different geographic backgrounds, different religious backgrounds, different racial backgrounds. I mean, I think that this is something not only that makes a good judge, but that makes a good human being, is to try to learn from people other than yourself. And I hope I've used the opportunities that life has provided me in my life to do that.
I mentioned in my remarks on Monday, public confidence in the court is extremely important, just as it is crucial that the public has confidence in the integrity of its elected representatives. Last week, there were news reports that the judge who overturned the Obama administration's moratorium on deep water drilling may own stock in energy companies. It's very damaging to the judiciary when a judge's neutrality can be questioned, which is why I think that obviously the ethical choices of a judge must be beyond reproach. What do you think are the most important ethical questions facing the judiciary, and particularly the Supreme Court? And will you be an advocate within the court and the judiciary for addressing these issues forthrightly and strongly?
Well, certainly, Senator Feingold, what Chairman Leahy opened up with, which is the whole question of making sure that a judge is recused from cases that a judge should be recused from, and there are obviously some hard calls there and some judgment calls. But taking those recusal rules very seriously is something that any judge should do. And I'm not speaking particularly about this case, the case that you mentioned, which I know nothing about. But in general, I think judges should approach their recusal obligations with a great deal of seriousness and care.
And when we spoke in my office, you indicated that you just recently learned that the Supreme Court is basically exempt from the Code of Judicial Conduct and the rules that the Judicial Conference puts in place to apply it, and so you didn't really have an opinion about it yet. But now that you've had a chance to think about it, do you think, for example, that Supreme Court justices ought to be able to have contacts with parties to the case that other judges can't?
Senator Feingold, I really haven't thought about that issue since we talked about it, and I would want to speak with the people whom I hope will be my colleagues about it before I answer that question. I think it's an important question and one worthy of real consideration.
All right. I want to talk with you now about the issue of forced arbitration. which I've been working on for about a decade. More and more powerful economic interests are forcing consumers and employees to bring their disputes not to the courts, but to a parallel legal system where the rule of law barely applies and where the outcome, I think, is stacked against them. A century ago, Congress passed the Federal Arbitration Act to allow parties who wanted to take their disputes to arbitration to enforce the results of the arbitration in court. In the last several decades, however, the Supreme Court has twisted this law to allow banks and mortgage companies, healthcare providers, big agribusinesses, and others to enforce so-called take-it-or-leave-it contracts that force people to use arbitration even if they don't want to. I think that's wrong, and Congress needs to change it. And just this past week in the Rent-A-Center case, the court held that in most cases where a claim is made that enforcement of an arbitration clause would be unconscionable, it would be the arbitrator who gets to rule on that issue. Do you understand why the Supreme Court's decisions in favor of powerful interests who want to force consumers and employees into arbitration against their will are so troubling to those who believe that our courts must continue to be available to enforce consumer protection, employment discrimination, and other laws written to protect the powerless from misconduct by the powerful?
Senator Feingold, I've not had an opportunity to read that case. It was not one that the Solicitor General's office participated in, and I don't have a view of it or much knowledge about it. I think that in that case, the Supreme Court was interpreting a congressional statute, and this is another of the areas where Congress does indeed get to state the rules. So to the extent Congress thinks the court got it wrong in that case or in any other regarding arbitration, I think it's appropriate and the court would and should respect what Congress does.
With regard to financial regulation, I've heard a lot of anger from my constituents about financial institutions that have acted irresponsibly and then looked to the public for a safety net when things went wrong. That's in part why I opposed the Wall Street bailout. To take perhaps the most egregious example, since the fall of 2008, the federal government provided approximately $170 billion in bailout funding to the insurance giant AIG. But in contrast to the many workers in Wisconsin and others who faced a cut in their benefits and pensions because of the recession, AIG insisted incredibly that it was contractually obligated to pay roughly $165 million in bonuses to its executives and employees, even as it was staying afloat with taxpayer money. I found it hard to believe that these bonuses were legally required. So I was intrigued by a recent piece written by Noah Feldman, who I believe you hired when you were at Harvard. Feldman called for a new constitutional vision that would, quote, focus on government's duty to protect the public, not the bankers who needed to be bailed out in the first place, unquote. In light of the recent financial crisis, how should the courts evaluate the constitutionality of government regulation of big corporations and financial markets and other efforts to protect citizens and consumers from economic disaster?
Senator Feingold, it's a very broad question, and I guess I couldn't answer it except, with respect to a particular case, a particular set of circumstances, a particular constitutional provision. I've not read Noah Feldman's article on this, so I can't talk about that. But I think, the duty of the court is obviously to apply the Constitution, to apply the statutes in any case that comes before it. And to the extent that the Constitution or some particular statute made illegal some of the conduct that you're talking about, the duty of the court is to enforce that.
One last question. As you know, the appointment of so-called czars by the White House got a lot of attention last year, although there was certainly a political component to some of the criticism. I did think there was some legitimate matter that needed to be explored, particularly since this seems to be a trend over the last several administrations, and I held a hearing on the topic. You've written a lengthy and impressive law review article about the President's ability to direct and control action by administrative agencies, so I'm interested in your perspective. Do you think there are any constitutional problems with presidents relying on non-Senate confirmed czars to direct administrative policy rather than the heads of administrative agencies? And how do you think Congress can exercise meaningful oversight over the czars operating within the White House when the White House counsel often takes the position that they should not testify before Congress about their activities?
Senator Feingold, I think that there are important considerations on both sides of this question. On the one hand, the President wants to have advisors in appropriate positions, advice he can trust, advice he can count upon. On the other hand, Congress has an important interest in accountability and making sure that the President and the President's actions can be held to account in this institution. I think that the balance between those two, when it comes to the President appointing certain people as czars or whatever you want to call them, probably is most appropriately determined by the political branches themselves, by the give and take, the back and forth between Congress and the President. Congress, of course, has many ways to express to the President that it doesn't like some set of actions that he's taking, including some appointments that he's made. I suspect that a judicial case on that subject might be a last resort rather than what seems to me the more common and I think the more appropriate way of dealing with a conflict and a disagreement as to this matter, which is Congress and the President kind of battling it out as to the way he should appoint people.
I thank you.
Thank you. And that will be it for this morning. We'll come back within a few minutes after the vote begins at 2:15. I'll then recognize the next Republican senator in line, then go to the next Democratic senator. Hope you get some lunch. Solicitor General, you're the ones that had to do all the work here this morning. I appreciate your testimony. We stand in recess.